LAW529 Confession, Lecture 2. Okay, in our previous lecture, we have looked at Section 17, Subsection 1 and 17, Subsection 2, which provides you with the definition of admission and confession. In our previous lecture as well, we have looked at the distinction between admission and confession. And we also have gone through the law relating to admission, in which we covered Section 18, 19, 20, 21, 22 and 23. Now the focus of current lecture is actually to look at confession, in which we are going to cover Section 17, Subsection 2, which explains to you again the definition of confession, and the focus on relevancy and admissibility of confession. We will look through Section 24, 25, 26, 28 and 29 of the Evidence Act. There are two other sections that I will not going to cover in this lecture, which is Section 27 and Section 30, which will be addressed in a separate video. Now, what is a confession? Now, let's look at the Evidence Act. When you refer to the Evidence Act, Section 17 sub 2 is basically the one that defines confession. A confession is an admission made at any time by a person accused of an offense stating or suggesting the inference that he committed the offense. You remember, confession here is an exception to the hearsay rule, and it is basically an exception to the hearsay rule. Despite that, it is the best evidence in the context of the best evidence rule. Okay? And the maker of the confession, which is the accused person here, is making a declaration which is detrimental to himself. Now let's look at what is confession. Now when we talk about confession, right, say you have the facts and issue here is whether Ali killed Mona, right? Ali stabbed Mona, right? And as a result, now police have conducted an investigation, and Ali now is put into custody, in which he is interrogated by Inspector Mat, right? Now what happened here is that Ali has been interrogated for 10 hours continuously. Right, he was interrogated 10 hours continuously. He was not given food. He was not given any drink. And Ali here is basically a diabetic patient. Right? And as a result of 10 hours of continuous interrogation, Ali made a, katakanlah, 10 pages confession. Right? Basically, he said that, okay, he knew Mona went, so basically he will illustrate in this confession as to how the incident happened. And katakanlah at second page of this document, he made a statement, yes, I killed Mona. I stabbed her 3 times. Right, and then he continued making further statement, whereby, therefore, at the end of the statement, he will have to read it back again in front of Inspector Mat, and he will sign at every page of this confession. So now what happened here is, during trial, you have the public prosecutor. So the public prosecutor here wished to tender the confession that Ali made in front of Inspector Mat as evidence in the court. So the issue here, can the prosecutor tender this particular confession as an exhibit in the court against Ali? Now, why is this confession a hearsay evidence? If you look at here, Ali now made the statement in this particular document. So this is actually a documentary evidence. Remember, when we talk about the definition of confession, confession is basically an admission. And when we go back to admission, admission is referring to a statement, either oral or in writing, or in a documentary form. So what happened here is, the prosecutor wished to produce this documentary evidence which housed a confession made by Ali. Now this is a hearsay evidence because this particular confession here is made by Ali, and Ali here will not going to be appear as a prosecution witness. You've got to go back to your foundation, to your basic, in which Ali, being an accused person, cannot give evidence for the prosecutor, and the only time when Ali is to testify in the court, it will be at the defense stage. So when you talk about here the prosecutor wishing to produce evidence in the court, we are talking about this to be at the prosecution stage. Now at the prosecution stage, now what happened here is that this particular document, the prosecutor will tell the court, Young Arif, Ali has made a confession before Inspector Mat, so I wish to produce this particular confession as a document, as an evidence in the court, and I wish to mark it as exhibit. So now, if the prosecutor here is to rely on the content of this confession in the court, to say that Ali actually has killed Mona, this is the one that makes it a hearsay evidence. Because this is a hearsay evidence, as a general rule, it is not relevant, not admissible. Okay, got that, yeah? So now what happened here? So when we talk about confession, right, bear in mind you have the definition of confession under 17 subsection 2. Remember, under section 17 subsection 2, the confession must be made by an accused person and he must admitted to committing a crime. Yeah, he admitted to committing a crime and he eventually been charged for that offense. So if you have on the facts that he has admitted to committing a crime, basically there is a confession under 17 subsection 2. There is no need for you to apply the case of Ananda Goda to determine whether A here made the confession or not. Now, section 17 subsection 2 is a concept section which provides you with the definition of a confession. Because of that, you are not going to tender a document which was made by Ali, which is a confession, as evidence in the court under 17 subsection 2. Because section 17 subsection 2 is only a definition section. So then, in the event that you wish to tender this particular document of confession made by A, you have to fulfill the relevancy and admissibility condition under section 24 to section 30 of the Evidence Act. So the one I meant to say here is that section 17 subsection 2 provides you with the concept and the definition of confession, but for you to tender confession as evidence in the court, the relevancy and admissibility provision will be provided for under section 24 to section 30 of the Evidence Act. Okay, now, say if you have a confession, look at this, the notes beside here, you will find that a confession is referring to an accused person here admitting to committing a crime. So you have to satisfy the definition under section 17 subsection 2. So this will be the first one, the first condition. Now the law says that, alright, as I told you just now, the relevancy, admissibility of the confession is depending on whether it satisfies section 24 to section 30 of the Evidence Act. Now, the prerequisite of a confession for it to be relevant and admissible is that it has to comply with section 24, right? Now, section 24 provides you with the voluntariness rule in which to say that the confession has to be voluntarily made. Now, okay, confession has to be voluntarily made. Now, under the law, if you recall what we discussed in the last lecture, we have a situation where A killed B. Yeah, A killed B, and A is making a statement to C. A said to C that I have killed B. Now, we discussed this example in our previous lecture when we look at section 21 subsection C. Under section 21 subsection C, even though the statement is a confession, it cannot be tendered as evidence relevant as confession because C here is not person in authority in the sense that he is not the person that is in which the accused person may make confession to. Now, under the law, therefore, for it to be a legally recognized confession under the law, C has to either be police officer rank, inspector and above, or C has to be a magistrate or a session court judge. It means that if C here, the person in which A made a confession, is not one of these two individuals, then it cannot be regarded as confession, but it has to be regarded as an admission under section 21C. So it means that for it to be a legally recognized confession, the authority to whom the confession is made is very, very important, in the sense that it has to be made to police officer rank, inspector and above, or to the magistrate. Now, if you look at the notes I have here, you will find that, okay, confession must be made by an accused person to police officer rank, inspector and above. This is actually provided for under section 25 of the Evidence Act. And confession also can be regarded as legally relevant confession if it is made to the magistrate or session court judge under section 26. The only difference between 25 and 26 is that for the confession to be made under section 26, the accused person must already be in police custody. Okay? So now, you compare this with the one that we have discussed just now, that is under section 21. 21 is where you have maybe the accused person here is making a statement to a lay person who is not police authority, inspector and above, and not to a magistrate. And section 21 also, he may make a statement while he is not in police custody, right? So in such situation, you cannot use it to be regarded as confession, because for you to make it relevant under confession, it has to fulfill the condition under section 24 to 30 of the Evidence Act. Now, let's look at section 25. So, alright. Now, before we look at section 25, so what we have here is basically section 17, subsection 2. You have a confession, right? If you have a confession, the first prerequisite that you have to satisfy for the confession to be relevant and admissible is that it has to comply with section 24 in the sense that the confession has to be voluntarily made. It has to be voluntarily made. Now, let's look at section 24. What is there under section 24? Section 24 says that confession caused by inducement, threat or promise when irrelevant in criminal proceeding. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat or promise having reference to the charge against the accused person, proceeding from a person in authority, and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceedings against him. Now, let's look at section 24 in your slides here. You see, section 24 is actually the voluntariness rule, and this is a prerequisite for a confession to be tendered as evidence in the court. Now, what does it mean by voluntary? The case of Dr. Motahashim basically has defined voluntary to mean statement has not been obtained by fear or prejudice or hope of advantage held out by a person in authority. So that is what it meant by voluntarily made. Now, under section 24 just now, you find that the provisions in section 24 says that factors that may make confession to be involuntarily made if there is inducement, you have inducement, threat or promise. Now, section 24 here does not give you any definition as to what does it mean by inducement, threat or promise. What you have to do now is actually to refer to case laws as to the meaning of threat, inducement or promise. Having said that, there is one more condition that may make confession to be involuntarily made. That is, the confession must not have the element of oppression. Right? If you refer to section 24, section 24 does not provide you in any way the meaning of oppression, because in section 24, oppression was not even mentioned. So oppression here is regarded as one of the elements that may make the confession to be involuntarily made, and it is incorporated under section 24 by virtue of the case of Datuk Mokhtar Hashim. Alright? So, because of this, factors that may make confession to be voluntarily made, I use the abbreviation of TOPI, threat, oppression, promise, inducement. Alright, now look at the PowerPoint. Now what does it mean by threat, oppression, promise, or inducement? Case laws are the one that define the meaning of the word threat, oppression, promise, and inducement. You have the meaning of threat in the case of Aziz bin Muhammad Din. You have basically oppression been defined in the case of Priestley. Basically, Priestley says oppression to be something which tends to sap and has sapped the free will of an accused person. That is what it meant by oppression. And then you have promise. So say for example, you have here, the accused person here has been interrogated, right? And the police officer, katakanlah Inspector K said to A, yeah, you make a confession, I promise your case will be handled by the most lenient magistrate. So that is actually a promise made by Inspector K, and that may make confession to be involuntarily made. So that is what it meant by promise. The other one will be inducement. Slight inducement, according to the case of Silva Durai, will make confession to be involuntarily made. Now what is inducement? Inducement is basically referring to, say for example, you say in the case of Mat Desa, you have a situation where the accused person here is being interrogated. He was interrogated by Inspector K, and Inspector K said to A, you better confess because my partner here is actually interrogating your brother in the other room. So dalam kes dalam kes Mat Desa, the court says that brotherly affection between a man and an accused person is regarded to be amounting to an inducement. Sebab what happened in that case is that the fact that the brother was at the other room and currently being interrogated, that may cause what? That may induce A to confess. So that one can result in the confession to be involuntarily made. Alright, so that will be the first one. The first one that you have to satisfy under section 24 is that there must be no TOPI. And number 2, right, let's sekejap. Okay, number 2, when you talk about under section 24, is that the TOPI here, the TOPI here must come from person in authority. Yeah, say for example, you have a situation where A here is being interrogated by Inspector K, and Inspector K is basically a person in authority. What is defined as person in authority? You have the case of R against AB, which defines person in authority to be persons ordinarily engaged in the arrest, detention, examination, and prosecution of an accused person. So in this example, you have A here being interrogated by Inspector K. Definitely, Inspector K will be person in authority. Now, the case of Aziz bin Muhammad Din further extend person in authority to mean someone who may have been clothed with authority. Now, what happened in the case of Aziz bin Muhammad Din is like this, yeah? I hope you recall Aziz bin Muhammad Din. We have basically explained last time the case of Aziz bin Muhammad Din. Remember, you have the accused person who is 21 years old, who has a girlfriend who is an underage 15 years old, right? So, the girlfriend was spending the night with A, and they have sexual intercourse. And what happened here is that G came home the next day. She was waited by the father at home. The father was very angry, forcing her to make a police report. So we have discussed this one last time when we discussed about the meaning of complaint. Yeah. So now, as a result of the police report, police carry out investigation. Right? When the police carry out investigation, what happened was A is brought to the police station. So A at that time was brought to the police station by two police officers, Inspector Z and Inspector Y. He was brought to the police station in a car, and at that time, A's father. So you have basically A's father, kita letakkan nama dia W, ya. Say for example W, which is Ali's father, accompanied Ali in the car that was driven by one of the inspectors to the police station. Now what happened in this case is that while they were in the car, Ali was sitting together with the father at the back seat of the car, and the father here put up a threat, yeah, to Ali. The father said to Ali, right, you better confess, yeah, when you go to the police station, because otherwise it amounting blah blah to whatever, yeah. So you have a situation here where the father here is the one who is putting TOPI on Ali. The issue here is whether Ali's subsequent confession here was suffered from element of TOPI or not. So that was the issue. And the consideration in the context of this case is whether the TOPI comes from the person in authority. Because apparently in this fact, the TOPI comes from Ali's father. In this case, the court decided that even though the TOPI comes from the father, there were two police officers sitting in front in the car, and the court says that since these two police officers did not make any statement to the father, or did not make any statement to prevent the father from proceeding with TOPI, the court says that the father here is clothed with the authority of the police officer. So that's why in the case of Aziz bin Muhammad Din, even though the TOPI does not directly come from these two police officers, there exists TOPI because the father here, who is close with the authority of the police officer, is regarded to be person in authority. Okay? Okay. And of course, that will be the second, yeah, the second part or the second element at section 24 that you have to satisfy. That is the first one. Just now there will be no TOPI. Number 2, TOPI must come from the person in authority. And number 3 is that the TOPI must have reference to the charge. Yeah, the TOPI must have reference to the charge. Now, what does it mean by the TOPI must have reference to the charge? This basically means that the threat, oppression, promise, inducement must relate to the charge. There is one case, yeah, the case of Ong Hok. What happened in this case is that you have the accused person here who is being interrogated by the police officer, and the police officer invoked TOPI. However, the police officer says that the police officer basically says like this, right? A, confess. If you confess, you will be rewarded in the afterlife. Maknanya, dia cakap dekat A, you mengaku salah, nanti dapat pahala, nanti masuk syurga. That will be an example of this particular case. And in this case, A confessed as a result of the statement made by the police officer. The court says that the TOPI here does not have reference to the charge. Maknanya benefit of reward in the afterlife, you dapat syurga ke neraka ke, is not related to the charge. If there is TOPI with that effect, the court says that it does not refer to TOPI in the context of section 24. So that will be the thing. And the last part is that the TOPI, yeah, if you look at that, the TOPI is sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it, he would gain any advantage or avoid any evil of a temporal nature in reference to the proceedings against him. Now, this particular part of section 24 basically relates to the court. It is the court that will decide whether the TOPI here is sufficient. Yeah, the court is actually analyzing the state of mind or the condition of the accused person, and the court here satisfied that the TOPI here is reasonable to cause accused person here to confess. In the sense that by virtue of the TOPI, the court believed that A confessed because, A confessed because he is able to avoid evil of temporary nature, or he can gain advantage of a temporary nature. Now, what does it mean? Right, it means that okay, you have here an accused person. Okay, the issue here is whether he trafficked drug, right? Yeah, whether he's trafficking drug. A here has been interrogated by Inspector Mat, right? Now, the condition, the state of mind of the accused person need to be examined by the court, and the court must believe that A made a confession by virtue of the TOPI that was imposed on him. In the sense that the court believed that A here made a confession because he can avoid evil of temporary nature, or he can gain advantage even though it is temporary nature. So A here is a diabetic patient, right? He's a diabetic patient. He was interrogated by Inspector Mat 10 hours continuously. He has no food, he has not given any water, and there were no medication. Now, what will happen if a person suffering from diabetic, put under pressure, not given food, medication for long hours? Yeah? For those of you who suffered from diabetic, this person will eventually, he may collapse and suffer from hyperglycemia. Maknanya dia boleh collapse dan dia boleh mati, because he is actually a diabetic patient. He must not be in a state of hunger for a long time. So he has to get his food, he has to get his drink, and he has to have his medication. Now, what happened here is that you got to imagine that here Inspector Mat is interrogating A continuously. You will find that A here will be under a lot of pressure. Yeah, he will be oppressed. Yeah, he will be oppressed to testify, because he will testify in the mind of A here. Yeah, he will be thinking that I'm so hungry, dah 10 jam I kena interrogate, no food, no water, and I have no medication. If I confess now, if I confess now, I will avoid this basically discomfort. Yeah. So maknanya in the mind of the accused person, he confessed because he is going to avoid the displeasure or discomfort that he is facing now. So he is avoiding that displeasure. He can have food, he can have medication. So he confessed even though he can avoid it only temporarily. Right? Maknanya the effect of confession will be much more lasting, because he is going to say that, yes, I'm a trafficker. Or he will gain advantage of temporary nature. So if I confess now, I'm going to have my food, I'm going to have my medication, I will not going to collapse, therefore I made a confession. So if the court believe that the accused person is making the confession because of that, then the confession may be regarded as involuntarily made under section 24. Okay? Now, for the court to determine whether the person made a confession is for that purpose, the case of Chang Boon Si, the court will do the assessment very subjectively. It means that the condition of the accused, the age, the personality, the characteristic of the accused will play a very important role to see whether he falls under this category or not. Right? Now, okay, let's look at an example of this point. Alright, so you have here A is being charged for trafficking. Alright? If we take out the fact that he may be a diabetic, yeah, and he has been interrogated for 10 hours continuously, right? Now, you imagine katakanlah A here is actually someone from KL gangster. So he's a hardcore criminal who could be siapa yang berlakon cerita KL gangster tu? So he could be the leader of KL gangster. So he used to street crimes, and setakat 10 hours of interrogation for him is nothing. So you have to look at his position here. If A is that kind of person, and compared to where A here is a person who just came from kampung, never been in KL before, all this while he's a very good person, dia dekat kampung, dia jaga atuk dia, right, dia pergi surau selalu. So you have to imagine this person compared to the person in KL gangster. Right? Maknanya kalau A ni is a kind of person who is very good, never disobey the law, you ketuk meja sekali je, already he is in fear. Right? So it has to be subjectively assessed on that position. Compared to KL gangster, yeah, who could have been murdered someone, dah potong-potong badan orang pun, so he's so used to this kind of violence, so you ketuk meja sekali, it doesn't affect him. So that is what it meant by the case of Chong Bu Si, right? So the TOPI, the court has to analyze it subjectively on the accused person, alright? So the moment you have this element, so once the element under section 24 is fulfilled, then the confession is regarded to be involuntarily made because of the possibility of TOPI. Now, what will happen, right? Now, what will happen here is that, say you have a situation just now, A, the issue here is whether A is trafficking, right? A was interrogated for 10 hours continuously, no food was given, no water was given, whereby at the end of 10 hours interrogation, he made a confession. He said that I am a trafficker. Yeah, he said that I am a trafficker. Now, here what will happen in court is that you have the prosecutor here who wish to tender this confession as evidence in the court. Now, if there was TOPI, what will happen here is that the prosecutor will come to the court. Yang Arif, the accused person here, has made a confession in front of Inspector Zack. So we wish to tender the confession made by him and mark it as exhibit. Now what will happen here is that the moment the confession is about to be produced as evidence in the court, the defense, that is A's lawyer, the defense lawyer said, objection Yang Arif, the confession is not voluntarily made. So what happened here, you have lawyer for A here objected to the tendering of this confession as evidence in the court. Now, the moment the accused lawyer here objected to the tendering of the confession in the court, the issue now here, should the confession be relevant and admissible or not? So that will be your issue. Now, once there is an objection, the main trial, which is to determine the actus reus and the mens rea of trafficking, will need to be suspended to allow for a trial within a trial. If you recall, we have discussed about a trial within a trial. We have discussed about challenging the relevancy and admissibility of confession when we discussed about the case of Anwar Ibrahim Sodomi 2. Remember, when you have Anwar Ibrahim Sodomi 2, this particular case, basically there was an attempt for the prosecutor to bring the DNA of Anwar Ibrahim, and there was a challenge on that one. And what happened here is that they have to suspend the main trial to allow for a voir dire trial. Yes, similarly, in this situation, the prosecutor here wants to produce the confession as evidence in the court. Once it is objected or challenged, the main trial has to be suspended to allow for a voir dire trial. Now, the voir dire trial will run as per the proper trial. The facts in issue for the voir dire trial will be whether the confession is relevant and admissible or not. That will be the aim of a voir dire trial. It only has one facts and issue, that is to determine the relevancy and admissibility of the confession. So what will happen here is that in the voir dire trial, the prosecutor will bring all evidence to show that the confession is voluntarily made. The evidence, katakanlah dibawa document. So what he did is that he bring in the document of the entry, logbook masuk interrogation, logbook at the cell where the person is being interrogated. You may want to bring Inspector Z who is doing the interrogation. Now Inspector Z, if he is the one who did interrogation to A before, he will have to undergo the same process of examination in chief, cross and re-examination, examination in chief, cross and re-examination, whereby at the end of a voir dire trial, the prosecutor here have the legal burden of proof to show that the confession is voluntarily made, right? And the standard of proof at this stage is that the confession here is voluntarily made beyond reasonable doubt. So that is what happened. Now the conclusion of this voir dire trial is that upon evaluation of the court may reach either, number one, if the confession is proven to be voluntarily made, then the confession becomes relevant and admissible as evidence in the court. Only then, in the open court, the confession will be tendered and marked as an exhibit. If, at the end of a voir dire trial, upon evaluation at the standard of beyond reasonable doubt, the court believes that the confession is not relevant, not admissible, then the confession cannot at all be mentioned in the main trial. So that will be the outcome of a voir dire trial in determination of confession, whether it was voluntarily made or not, whether it should be relevant and admissible or not. Okay, so you got that. So this is actually the prerequisite in which all confession, if it is to be tendered as evidence in the court, it has to satisfy section 24. Now, having said that, so now you basically have section 17 subsection 2, a confession. It falls under definition of confession, right? The confession has to be voluntarily made, section 24. There were no TOPI. Now, for it to be a legally relevant confession, the law says that confession has to be made to police officer rank, inspector, and above. Yeah? And this is actually provided for under section 25 of the Evidence Act. Now, let's look at section 25 of the Evidence Act. Confession to police officer below the rank of inspector not to be proved. Subsection 1. Subject to any express provision contained in any written law, no confession made to a police officer who is below the rank of inspector by a person accused of an offence shall be proved against that person. So it means that for there to be a confession and for it to be admissible in law, it has to be made to police officer rank, inspector, and above. Another one, alternatively, if you don't make the confession to the police officer, section 26 can also be considered. Now, what is under section 26? Section 26 refers to confession by accused while in custody of a police officer not to be proved against him. Subject to any express provision contained in any written law, no confession made by any person while he is in the custody of a police officer unless it is made in the immediate presence of a president of a session court or magistrate. So, maknanya, under section 26, if an accused person is already in police custody, now what does it mean by police custody? Definition of police custody, you have this in the case of Sambu. The case of Sambu basically says that a person is to be regarded as within police custody if, upon his attempt to run away, he will be followed and caught by the police. Maknanya, police custody, according to the case of R and Sambu, is a state of being watched. Where if he tries to run away, he will be he will be captured and put into custody. That is what it meant by police custody. Maknanya tak semestinya you have to confine in one room to be regarded as in police custody. The fact that the police was watching you and observing you, and when you try to run away, they will catch you, that is already within the meaning of police custody. Now, for section 26 to apply, maknanya if the accused person in police custody, confession can be regarded as relevant and admissible if it is made in the presence of a magistrate or session court judge. Yeah? So that will be what under section 26. Now, so you have here, therefore, two provisions in which for it to be a relevant confession, besides that it has to be voluntarily made, it has to satisfy one of these two situations, whereby the confession can either be made to police officer rank inspector and above or to a magistrate. Okay. Now, having said that, unfortunately, we have section 113 of the CPC. Right? Now, what is in section 113 of the CPC? Now, let's look at the section. I hope you try look for this provision and read it. Now, what is in section 113? Sekejap ya. Now, section 113 of the CPC says that, yeah, admission of statement and evidence. 113 subsection 1. We are talking about criminal procedure code here, yeah. 113 subsection 1. Except as provided in this section, no statement made by any person to a police officer in the course of police investigation shall be used in evidence. Now, under section 113 subsection 1, an accused person here is being interrogated. He is interrogated by police officer. So normally when you talk about interrogation, this happens during police investigation stage, right? If during this particular stage, he was interrogated and he confessed. He says that, yes, I'm a trafficker, I traffic drug, I have been trafficking since I was 18 years old. So he made a confession which satisfied the definition of section 17 subsection 2. Section 17 subsection 2, the law under section 113 says that whatever statement that the accused person made to police officer in the course of police investigation is not relevant nor admissible to be used against the accused person. So, this particular provision under section 113 subsection 1 basically disallow any statement made by the accused person to police officer, rank inspector and above. Now, having said that, so we basically have section 25 that allow for confession to be made to police officer, rank inspector and above. But we have another provision, that is section 113 of the CPC, that is allow for any statement be used against him. Now, in this context, the law on section 113 will prevail because this will be the specific law. So what happened now is that the moment the accused person is being interrogated, he may make a statement to the police. The statement cannot be tendered as evidence in the court, even though it is confession, it comes from him, even though he made it voluntarily, it still cannot be used against the accused person. So that is the condition under section 113 of the Evidence Act. Okay? So okay, I hope you get that. Remember, section 113 of the CPC is a newly incorporated provision which was incorporated in early 20s, in early 2000, and this provision basically overruled the earlier provisions relating to caution statement. Alright, so that will be the law relating to confession. You have the definition under section 17, you have the voluntariness rule under section 24, and who can you make the confession to? You can make it to police officer under section 25. However, this will be subjected to by CPC section 113. So what you have now is that if you made a confession to the magistrate under section 26, then that will be a situation where your confession will be saved and it can be used as evidence in the court. Alright, so that will be section 24, 25 and 26. Now let's move on. I will not going to discuss with you section 27 because section 27 is slightly different, the context of the scope of section 27, but I want to look at section 28. Now what is section 28? Now section 28 here is referring to confession made after the removal of TOPI. Yeah? Sub 1. If such a confession as is referred to in section 24 is made after the impression caused by any such inducement, threat or promise has, in the opinion of the court, has been fully removed, it is relevant. Now, the circumstances under section 28 is like this. Yeah? Contohnya, A here is being interrogated for trafficking. Right? Katakanlah he was put in custody at 10 AM in the morning. He was interrogated for 10 hours, 10, 11, 1, 2, 3, 4, 5, 6, 7. Ya? Okay, katakanlah he was interrogated for 8 hours, 10, 11, 12, 1, 2, 3, 4, 5, 6. So at 6 PM, the police completed the interrogation and he is left to his cell. So, dibawa ke cell. So, you have here, remember under the Criminal Procedure Code, if a person committing a crime under the CPC or general ordinary criminal crime, ordinary crime under criminal law, he is being taken to police custody. He can be interrogated only for 24 hours. So, after 24 hours, right, he can only be put in custody after 24 hours, within 24 hours. After 24 hours, he has to be brought to see the magistrate to get what you call a remand order. Remand order is where the court will give an order. The maximum day is 14 days. Normally what the court do is that the court will give it in a shorter period, 3 hari ke 4 hari ke, and then upon expiry of that day, the police will go to the magistrate again to get a further remand. So this is a remand order. Yeah? Untuk a further investigation where you have to interrogate him. Yeah. Now what happened here? You have the accused person here who is being interrogated, katakanlah by Inspector Mat. He was interrogated from 10 AM in the morning until 6 PM. So after the interrogation, he was brought to the cell. It was a long, continuous interrogation. He was not given he was not given food. Only after the 8 hours of interrogation, he was given food at 7 PM, and then after that, he is left to his cell, where he is not disturbed at all. The next day, pukul 9 pagi, 9 AM, he is brought to see the magistrate. And here, in front of the magistrate, the accused person here confessed. So he made a confession to the magistrate. Now, if you look at this one, maybe after long hours of interrogation, pukul 10 hingga 6 tu, he made a first confession to Inspector Ali. So you have confession 1. He said that I am a trafficker. And then he made second confession to the magistrate the next day, around 10 AM at the magistrate court. Now, if you look at this one, there are 2 issues that you have to consider here. Number 1, whether the confession of A to Inspector Ali relevant and admissible or not. That will be the first issue that you have to consider. And the second issue here is whether the confession of A here to the magistrate relevant and admissible or not. Now, if you look at this one, you will find that confession of A to Inspector Ali may not be relevant and admissible, right? May not be relevant and admissible, and basically you may have the law under section 25, you may have the law under section 24, you may have section 113 of the CPC, right? That could be the factors that may make confession of A to Inspector Ali not relevant, not admissible. However, after quite a long rest, pukul 7 dia masuk sel, 8, 9, 10, 11, 12, 1, 2, 3, 4, 5, 6, 7, 8, 9. So he had a rest about maybe more than 12 hours. Whereby in front of the magistrate, A said to the magistrate, Tuan Magistrate, saya nak mengaku salah. I want to make a confession. So the issue here now, can the confession be relevant or not when he made it to the magistrate? Remember, confession to the magistrate here, of course, need to be considered under section 26. Section 24 is a prerequisite that the confession has to be voluntarily made. Right? Now, you've now got to see section 28. Section 28 is a situation where they were TOPI before, but the TOPI now has been successfully removed. Now, under section 24, what the magistrate got to do here, when he is recording the confession of A before him, he got to see whether the confession was voluntarily made. Now, if there were TOPI, he has to analyze whether the TOPI has successfully been removed. If the TOPI was there in the beginning, and if it is successfully removed, the confession that the accused person made before the magistrate can be relevant and admissible. That is when you apply section 28. So the consideration of section 28 here will become relevant. Okay, that will be section 28. Now let's look at section 29. Now what is section 29? Confession otherwise relevant, not to become irrelevant because of promise of secrecy. Now section 29 here, you're talking about, it is not TOPI. Yeah? Okay, accused person here made a confession. Yeah, accused person here made a confession. But the police officer, katakan you have the police officer, right, may invoke element that looks like TOPI but not TOPI. Nampak macam TOPI but not TOPI. Look at section 29. If such a confession as is referred to in section 24 is otherwise relevant, it does not become irrelevant merely because it was made under promise of secrecy, or in consequence of a deception practiced on the accused person, or for the purpose of obtaining it, or when he was drunk, etc., etc. So that particular element are not TOPI. Example, A was interrogated by police officer Z. Yeah, Inspector Z. Z said to A, okay, A, this one you have to disregard section 113, yeah. When I analyze this particular example, you just disregard that there was the section 113 of the Evidence Act. Now when you look, section 113 of the CPC. Now what you have here is that Inspector Z interrogate Ali, and Inspector Z said to Ali, right, dia kata, Ali, you better confess. I promise I am not going to tell to any single person in the world as to what you say. Maknanya, you have here Inspector Z here made a promise of secrecy. Promise of secrecy. So if that kind of promise of secrecy, betul tanya, betul ya jangan cakap dengan orang? Ya betul, ya saya adalah trafficker. So you have that situation. So the moment Z made a confession, the moment A made a confession to Inspector Z because of promise of secrecy, this is not TOPI in the context of section 24, and this is instead situation under section 29. That statement that he made, which is a confession, can be relevant and admissible. Alright? So that is the position under section 29. Okay, now, so what we have discussed basically today is actually to look at confession, the definition under section definition under section 17, subsection 2, and link it to the relevant provisions on the relevancy and admissibility of confession, in which we discuss section 24, which is prerequisite of all confession, section 25, 26, 29 of the 28, 29 of the Evidence Act. Right, we complete this slide. I will discuss with you section 27 in the next slide.